Yeah. Okay, good afternoon, everyone. It's great to have everyone here. We want to welcome you to today's CLE session, Building Business, Building Communities, Legal Insights for Enterprise and Micro Enterprise Development and Success. Today, we're really excited to introduce you to Legal Services Micro Enterprise Program. We're going to highlight the incredible work that they're doing in our communities, and you're going to hear from those who have dedicated their time and expertise to helping these micro enterprises, small businesses, and nonprofits in our local under-resourced communities. And not just how they help them survive, but also thrive. My name is Katie Crispin, and I am here with many other members of our legal community, and I proudly serve on the young boards of legal services. The YFB, it was founded in 2010, is a group of young volunteer attorneys and law students who are committed to increasing the community awareness, providing volunteer and financial support, and cultivating a new generation of advocates for legal services. So being a part of, I could speak for myself, being a part of YFB has been very rewarding. It keeps you connected. It allows you to give back to the community and also supports your professional growth. As with many other forms of volunteering, what you gain often far exceeds what you give. So if you're interested in getting involved with that, feel free to reach out to me directly, any of the panelists here today, or contact Legal Services to learn more. Before we dive into today's content, I want to take a moment to thank everyone who made this CLE possible. Special thanks to the development team at Legal Services, especially Louisa Gregory, to Marlene Elliott and the Micro Enterprise Program team. And I'd also like to acknowledge our dedicated Young Friends members, especially Vanna Shaw, Ebony Shekels, and Luke Jackson, who you'll be hearing from later today. So just to give you kind of an overview of what you can expect from today's session, first, we will have Marlene Elliott, who is the managing attorney of the Micro Enterprise Program. She's going to provide you with an overview of the program, explain a little bit about the client intake process, and share some common legal issues that arise when working with micro enterprise clients. Next, you'll hear from Ebony Shekels. She is in-house counsel at the Metropolitan St. Louis Sewer District. She's going to talk about her volunteer work with the program, how she advises clients, and how she balances that work with her full-time job. Luke Jackson will be our next speaker. He's an attorney at Weigel Law. He's going to walk us through key legal and ethical concerns when advising small businesses, focusing on two main topics of how to account for potential disputes during company formation and also navigating those disputes in pre-existing companies. Finally, Marlene is going to introduce us to our special guest, Shelby Farr of Shelby Marie Luxury Fragrance Bar. She's going to share her journey as a business owner, her experience working with Marlene and the Micro Enterprise Program, and how she's navigated the challenges of launching and sustaining her business, especially through the period of COVID. So thank you, Shelby, for being here. We're really excited to hear from you. And just as a note throughout the presentation, if you have any questions or comments, feel free to drop those in the chat. We'll have time at the end to address audience questions, and speaker contact information will be provided throughout and also at the end for those interested in following up for further discussion. So with that, I'm going to stop talking. I'm going to turn it over to Marlene to kick things off and get this started.
Okay, thanks, Katie, so much. Hi, everybody. Thank you so much for joining us. I thank you. I am the managing attorney of the Micro Enterprise Program, and I'm just going to briefly talk about the program overall and what kind of services we offer, just so you guys know what we're doing. And we're always, welcoming any kind of help any pro bono attorneys want to offer, maybe just doing presentations or actually working with our clients. So let me just get started in my PowerPoint. Yeah. Thanks, Louisa. All right, you could go ahead and can I click it or yeah, you'd have to click. Okay. So basically, we offer transactional legal help to entrepreneurs and nonprofits, and we cover a wide range of legal services for our clients, whether it's forming the entity, operating agreements, corporate governance, which basically means bylaws for nonprofits, contracts that entrepreneurs may need, whether it's, customer contracts or maybe a partnership contract or something like that. Real estate issues. The biggest real estate issues we tend to see are commercial lease issues, and we do help with that. We also dabble a bit into intellectual property with trademarks and copyrights, also employment issues um, with with entrepreneurs. We touch upon zoning. We try to give them guidance based on where the business location is located. Also, nonprofit compliance, which can be a wide range of things, but mainly making sure our nonprofit clients know to keep up with their 990s and with their annual filings with the state. And also, we help our nonprofit clients obtain tax exempt status based on what their needs are. So overall, those are the types of issues that we typically handle. So, okay, next slide. And so we also, along with our one-on-one presentation, along with our gotta go back. um sec. Just one second. But along with our one-on-one representation of our clients, we also offer a lot of legal education, not only to our clients just to get them aware of what's going on, but to the community. We want to reach out to not only the low income community, but there is a huge gap for entrepreneurs where they may not qualify for our one-on-one services, but they don't make enough money um, to pay for an attorney for themselves. And so, basically, we're trying to get some legal education out there to help people guide them through, running their business or starting a business. So we work with community partners, such as the St. Louis County Library, Justine Peterson, Urban League's Women's Business Center, just to name a few. And we offer presentations based on whether they have a business planning class that they want us to talk to, or just, community events that they may hold and they want us to hold a presentation. So we definitely do that. And we also offer regular legal clinics with those community partners I named and a few more. And some of them are monthly and some are quarterly or bi-monthly or things like that. So we offer a lot of legal education to the community along with our one-on-one representation. Next slide. Thanks. And so just to give you guys a quick overview of what types of presentations we do and um, yeah, and types of presentations that we do, and other pro bonos can do as well. We talk about legal entities, different types, intellectual property basics, how to start a nonprofit, maybe employment issues, or contracts. So those are the types of presentations that we typically offer, but pro bonos can come in if they have a special niche or special presentation they'd like to offer. We definitely get that going and promoted. So, okay, next slide. And quickly, just to go over what we don't handle, our patents, litigations with exceptions. If there's a small litigation issue or negotiation issue that a pro bono can handle, we will help clients with those issues. We don't represent landlords mainly because we don't want to conflict out any of their tenants who might need help from our housing department. Business divorces, you guys know that can be messy, so we just don't wade into that. Bankruptcy, adult entertainment, and I think there's a couple more liquor licenses, and we don't handle client funds. So, yeah, so basically, um, that's the general gambit of what we don't handle. Next slide. And so to talk about quickly the process of becoming a client, um, anyone who's interested would contact our paralegal, Richard. You can reach him at his email, and we also have a CED email that you can get at the end of this slide. Just to let you know, nonprofits will need to fill out a group eligibility form to let us know where they are in the process of forming the nonprofit. Also, potential clients will have to go through intake, and basically, um, we look at the household income of the clients, and the household income cannot go over 300% of the poverty level, and they can't have assets more than $10,000. But there are, you know, allowances that don't count towards that. So the clients definitely have to have a car, or if they have a house, we don't look at those. There's at least certain things that we expect people to be able to have, and we don't count that against them. So if you know anyone who's interested, go ahead and contact us, please. And then once a person goes through intake, then we'll have a meeting to figure out their legal needs, and then we'll set them up either with a pro bono or in-house attorney. Next slide. Okay. And quickly, some of the issues that we've seen our clients have are operating without a legal structure, which I'm sure a lot of business attorneys have seen. Reliance on LegalZoom, that could be tricky because clients are paying for these documents and they may not always have the right information included in them. Clients wanting to do too much too soon. We try to slow them down and get them to think about focusing on one or two things at a time so that they're not getting overwhelmed with trying to start the business. Sometimes they don't understand the difference between the nonprofit and for-profit entities. Sometimes they're commingling funds, which I do run across a lot. They need help reviewing commercial leases a lot of times. And they also need to know how to sign business contracts on behalf of their business. Sometimes they're not aware of that. And also, we see clients who come in with no business strategy or no idea of how they're going to start. And we kind of guide them towards the business planning classes so that they get some more help. After that, next slide, I believe. Yes. So we're going to stop here, and I'm going to hand it off to Ebony real quick so that she can do her presentation, and I will address some of the questions that I've seen in the chat already. So I'll handle those later. Thanks, everybody.
All righty. Now I'll wait for my slides to come up. All righty. So as mentioned prior, I am going to share the volunteer attorney perspective. Next slide, please. So who am I? As we've already mentioned, I'm Ebony Shekels. I serve as in-house counsel for MSD. I've been in that role as of next Friday, the 16th, 15th, 16th. one of the days. It would make 3 years. And I began volunteering with legal services around that same time. And it's been a blast. It's been a blast. It's been a little ebb and flow, but it's been fun for the most part. And I have personally dubbed myself a small business nerd. I've been involved with small business long before it was sexy. I think in 2010 or 09, maybe, I minored in entrepreneurship in college, and it's been a roller coaster since then. And finding legal services and being able to sharpen and hone and even expand my skills, working with entrepreneurs and business law, it's been fantastic. So, next slide. And so you're probably thinking, man, I'm seeing MSD all over the news all the time. I know you guys are busy. How on earth are you finding extra time to do this? Well, it's a balancing act, right? As we've all heard, that work-life balance, it comes into play a lot more when you're taking on additional legal matters that are outside of your work. And it can be a juggling act, as you see this gentleman here doing his best. Right. And sometimes the sky is not as blue. Sometimes it's pouring and you're like, why am I doing this? But that's because you love it. Right. And so I tell people that I treat my experience as a virtual boutique law firm of my own, and you are in control of absolutely everything: your time, your schedule, how often you guys are meeting, the days of the week you're meeting. And it's within reason, right? Within reason with your client whenever they're available, because what you come to learn is that while you're getting off, well, I get off at 4:30 every day, and sometimes they're getting off at 4:30 or 5 o'clock or 6, and they are totally fine with whatever schedule you may put out. But again, it's controlling what you can control. And more importantly, be realistic and honest about your workload. Marlene or Richard will always ask you, hey, what would you like to take on? Entrepreneur A has X, Y, and Z. Entrepreneur B has a slew of things. Entrepreneur C also has a slew of things. You can take on one matter, you can take on two, you can take on what you perceive as the easiest one, or if you are feeling fantastic that day, you can take on all of it, right? But again, it's just being realistic about your workload. If you're busy and there's hellfire at work, then maybe not so much, right? But again, it's all up to you. All right, next slide. And so with that, I'll kind of piggyback from a little bit of where Marlene has left me with some of the common topics. Oh, what happened there? Some of the common topics and misconceptions that I've experienced. Well, I'll keep going if that's okay, even though you may not be able to see what I can see. And so my first topic is the employee versus independent contractor debate. Now, although we are not being tapped to do any business advising per se, it'll be more of a walking your client through their own thought process, right? And so what does that mean? That means these are all going to be true stories with a little bit of anonymity. You've all seen Nemo. You know the word I'm trying to say. So bear with me. Skip that word for now. And so there was a client that I had. He and his partner were looking to start a non-emergency medical transportation company. And they were going to have all these drivers and needing services for persons to get from home to appointment and back. And so they're like, oh, we're going to hire all these employees, but they wanted all their employees to have the benefits or the lifestyle of an independent contractor, right? And so you kind of give it a real world example. You give them the Uber example, right? Well, do you want to be able to have them provide their own vehicle, their own insurance, deal with their own taxes, all that good stuff, right? However, you two are in agreement with the scope of the work that will be done based on your criteria. And they're like, well, yeah, we need more of a hands-off approach. Well, you're not looking for an employee, right? You're not looking to control the what, the where, the how, dealing with taxes and providing the vehicle. You're looking for an independent contractor to have less control and just be able to give that one lump sum payment when the time comes after the service has been done, right? And so you'll also have someone who may say, oh, well, I need an independent contractor agreement in order to hire someone to do my graphic design or to put together my website. And I'm like, okay, I can hear you, but hear me, right? Is this what you mean? Although independent contractors and sometimes a work for a hire situation can be similar, they're not the same, right? And so some of the major differences that I'd like to highlight with the work for hire situation is that the hiring party has a lot more control than the independent contractor. being hired may have, right? You're in control of that end intellectual property that's going to be created. And even more importantly, the intellectual property being created will be remain in the ownership of the hiring party. So if you're hiring someone to do your website, that website will be yours, right? That person who created would no longer have control over it. So again, just hearing your client and walking them through their own thoughts and understanding what they need versus what they want. All right, next slide. And so my intellectual property combo there segues perfectly to this one. And while I can go on and on about the nooks and crannies of what you see here, I'll go with my favorite one, which is the last bullet here. And again, this one really, protecting that brand, protecting the business really hones nicely to active listening and being able to decipher what your client is needing versus what they're telling you they want. And so here we go. I have my domain name, so my slogan should be available for my trademark. And I go, oh, okay, where should I start? Right? And so, yes, you may have your domain name, and that may be the name of your business, right? It's available through whatever they want through GoDaddy, Canva, Strikingly, whatever platform they're using to house their website. However, that is not the same as that name being available with the USPTO, right? You don't want to use that name and think, oh, it's there. I'm going to get going and get a 2D refusal for likelihood of confusion with someone else, right? And so I murky it a little bit more by telling them that although it may not be available just because you're using that name as your website, you can use a screenshot of your website as a specimen, right? To prove that this is your business. It is identifying you as a sole source of your goods or your services as evidence or proof for your application to get a trademark, right? To get that circle R. And then that's when they go, ready? And I'm like, okay, let me back up a bit. Let me make sure that we're on the same page. And it usually goes accordingly, but the best thing you can do is make sure you're not using too much legalese or legal jargon, because although, we're lawyers, we beat our chests, yeah, I passed my bar exam, let me at it. They're not there to see if you know the words, the big words. They're there to understand what they need for their business and how to better protect their business. All right, next slide. So I have a few funny stories for the business license and permits section of my presentation, but obtaining a business license in St. Louis City requires a number of steps, and it certainly depends on the nature of your business. Not all steps will pertain to all businesses. It just depends. But I will say obtaining an EIN number is kind of wonky, and it shouldn't be, because I've gotten persons that will say, oh, well, I paid such and such to get it for me or to obtain it. And my first thought is, it's free. Like, no, who did you pay? No, 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 no. As long as you have it, that's fantastic, right? You need it. It's important, but it should have been free through the IRS, right? But they're relieved, upset that someone has, pulled a fast one. But as long as they have it, it's okay, because it is required as a step to obtain your business license in the city of St. Louis. I'm going to jump to the home occupancy waiver because that's where my next story comes into play. So I had an at-home based jewelry company, jewelry and clothing. And one day she came to me and said, I've been operating my business for a few years now. And do you think I need a home occupancy waiver? And I thought, okay, where do I start? She's been operating her business for a few years. However, in order to obtain a business license, you do need a home occupancy waiver if you're operating out of your home, whether you rent or own, right? And so that dawned on me that she's been operating without a business license all this time. And so her and I went through that aspect and to kind of let her know, it's a $50 process. If you are renting, a landlord or property manager will need to notarize some documentation saying that they approve of you operating this business out of your home. But if you're owning, right, if you have your own mortgage, and then you just have to show proof that you own, which can be as simple as showing a state ID or a valid driver's license. Now, the commercial occupancy permit, it's a wee bit straightforward. It's basically just an inspection to make sure your building is up to code. However, the pricing for that depends on the square footage of your space. And so I believe if it's 3,500 square feet or more, that price is about $160. And if it's 3,500 square feet or less, it is half the price. And all of these things, including other things, depending on if you're in a health business, which is a whole nother monkey to get into on its own, and a few others, are required for that graduated business license, which that is a requirement for any business operating in the city of St. Louis, which also has a bit of a fee connected to it. But again, if you're operating out of your home, that fee will only be $25. And that business license should be renewed every summer around now, actually, I think May or early June. All righty, next slide. All righty, so I won't touch on operating agreements too much because I know Luke has a fantastic presentation ready for you on ethics and the murkiness of operating agreements, but operating agreements are mandated by the state of Missouri. And although they are not required to be filed with the Secretary of State's office, you are required to have one tucked away somewhere. And they will need to kind of pan out how your business is operated, how your books are kept, and the ownership of the business, right? And the bookkeeping, separate bankings are things that Marlene Elliott touched on before, which it also makes me cringe to my soul when I hear persons commingling monies and all that stuff. I think it's IRS, 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 run, like fix it, fix it. And sometimes the financial aspects of the operating agreement can be a bit of a not so fun button for people to talk about because they're thinking, well, how do I maintain my booking? What software should I be using? Who should I be talking to? And again, we're not here to do the business advising, right? Just kind of walk persons through their thought process, which can be a bit of an uphill battle. But the ownership interest is what I want to kind of close out here with. I tell persons that, you know, as we're going through the operating agreement and making sure everything looks sound as they would like, I tell them, you know, someone has to be able to break the stalemate. Right, we can't all have the exact same equal amount of percentage in the business, and so we're not looking to have that same level of agreement as the text message the Friday night, hey, let's get those tacos and tequila. You're like, great, like no, the business decisions will be a little bit more complicated than that, and someone has to be able to break that stalemate there. So next slide, please. So that's all I have for you. A few final takeaways. Again, you are always in control. If ever you feel like, oh my goodness, this is going cattywampus, I have to get out of here, then you've lost control of it. And that's okay, right? Just be honest about your workload and what you can handle, what you can't handle. Effective communication, active listening will always be your best friends here. Sometimes you may have to tell your clients what they need or what they actually don't need that they may already have and how to kind of work around that understanding. Good bedside manner will take you a long way. Having patience with your clients and listening to them, because sometimes you'll find that you're explaining things 6 different ways and you're like, what is happening here? Or, oh my goodness, I asked them to do X, Y, and Z and we're struggling a bit. That's okay, right? They're learning as they go and they're coming to you, trusting them to say, hey, I need help. How do I do this? Even if the answer is, hey, I don't have the answer, but let me figure out how to help you, right? And sometimes that's giving them contact information for someone who can help them in a different department or someplace else in St. Louis City to kind of help their business move along. And if all those fails, have fun, right? Like, yes, it's still legal work, but this isn't work. We're not going to the office to do this. This is something we're entering into on our own in our own spare time. And I hope that you are having fun doing something extracurricular, even though this is technically work. Alrighty, that's all I have for you. Here's my contact information. This is my direct phone number in my office, my work email, and the last one is my personal email, which I see 2 million times a day. So the best way to contact me may be that if you have any questions for me. Alrighty, that's all I have. Thank you.
All right. Next, we have Luke Jackson. He is coming up, and I'll let him get started once we get his slides up.
Okay. Yeah, good afternoon, everyone. My name is Luke Jackson, and I will be the next presenter. I'm the litigation partner at Weigel Law. I'm a member of Legal Services Young Friends Board, and my practice areas involve partnership disputes and property litigation and complex commercial litigation. And so today I'm going to be speaking about ethical and practical concerns for attorneys who are representing partnerships in some capacity. And so I've broken it down into two main topic categories. The first one focuses on early formation stages of partnerships, and you're retained and you're helping a group of people form a new partnership. And then the second focuses on there's a pre-existing company and you're hired and you're wading into a partnership dispute within a pre-existing company. And so we can go ahead and skip forward a couple slides. One more. Okay. And then one more. Okay. So in this one, you've been retained to help a group of people form a new partnership. The first step, and perhaps the most important step, is to clearly determine the nature of your representation and to consistently communicate the nature of that representation to the client and the non-client partners. So if you're retained to represent just one of the partners in negotiating a company structure and company documents, your obligation as an attorney is to that partner, and not to the partner group and not to the company itself. It's your client partner's interest that you'll be protecting as you negotiate and draft up an operating agreement. In this situation, there really should be other attorneys involved who are representing the other partners at the table, just to make sure you don't run afoul of any ethical concerns down the line that you were taking advantage of unrepresented parties. It's not likely, but it's always better if you're representing one partner that the other partners have attorneys as well. More likely in this situation, you'll be retained by the partnership itself. Your client is the company or what will be this new partnership. It's the easiest approach in my opinion, because then it kind of removes the barriers and you get to work closely and sit down and talk with all the partners and make sure that the operating agreement, the other governing documents align with the needs and the expectations of all the partners. And keeping the boundaries of your representation crystal clear, that's going to be a common theme throughout this whole presentation, because that is one of the most common ways attorneys get themselves into troubles in general, but especially when dealing with companies and partnerships. Next slide, please. So this part always makes me sound super pessimistic, but new business partners are usually fixated on the idea of like their future success, and they haven't even considered that they are going to disagree at some point. They'll often try and rush you through the formation or operating agreement stage and not realize that they're actually creating this whole slew of future problems in the process. It's our job as attorneys to raise the potential problems at the outset and account for them in how the company documents are actually drafted up. For me, I do this usually with an initial lengthy discussion with all of the partners, and we will run down the list of the most common problem areas. And we, as a group, with all of us there, will come to like some sort of agreed upon solution. And that's what will go into the company document. Now, assuming that you're representing the partnership itself, I've also found it useful to kind of get a good idea of the sophistication levels of the various partners, so you know who might need additional instruction. And so, for example, if one partner is an experienced business person who already owns and operates numerous businesses and the others have never done this before, then those inexperienced partners are going to really benefit from you breaking down any sort of complex legal or business discussions into more basic details for them. Otherwise, they might not realize that a certain contract provision or agreement provision is not actually what they wanted at all until they're fighting about it down the line. So trust me, the time to handle potential future problems is early on while everybody's happy and willing to compromise, and not after a partnership dispute is already kind of broken out. Next slide, please. So I'll go into more detail here in a bit on some of these examples and how you can address it in an operating agreement. But in my experience, these are some of the most common ones. They come up constantly. If we're wading into a partnership dispute down the line, it is almost always revolving around one of these categories. Next slide, please. Another reason, and Ebony briefly touched on this, is to have an operating agreement in place. And why they're so important is if the partners fail to put an operating agreement in place, then future disputes will almost certainly be governed by Missouri's Limited Liability Act or whatever the respective state equivalent is. And that's rarely a good thing. It's very general. It's silent on most of or some of the most common aspects of partnership disputes. It very rarely reflects the will of the partners, what the partners would have chosen for themselves. And on rare occasions, the lack of having an operating agreement in place for like an LLC has been a factor that courts have looked at, and they've used that to kind of further justify. Not in itself, there's a bunch of factors, but the lack of an operating agreement has contributed to a court's decision to pierce the corporate veil and hold sole members liable for the acts or the harm caused by their LLCs. They kind of viewed the absence of an operating agreement as kind of an example that the company was kind of a sham. Next slide, please. And so think of operating agreements as, and while you're drafting them, as kind of the last best chance to anticipate and preemptively solve problems with the input and agreement of all partners. That makes it much less likely if they had the buy-in and they helped everybody, they're engaged in the process of agreeing on what we're all going to operate our business around. It's much more unlikely that down the line, we're not going to find some way to get a resolution that doesn't involve everybody going to court. And so here's some examples of those other issues I brought up here, and it's how I have routinely thought about trying to fix them, or maybe the questions you want to ask. And so with voting rights, you're going to want to clearly lay out what everyone's voting shares are, what their percentages are, when a vote is required, when various majority votes are required. For example, should we require a unanimous vote or a majority vote to borrow more than $10,000? Or to change a company's S corp election, or go and assign a new business purpose. We thought we were going to open a coffee shop, but now we've all agreed we want to open a nail salon. Well, we want to make sure that if we're going to do that, everybody has to agree on it, or spell that out in the beginning. Payment of distributions. Specifically clarify each partner's proportionate share of distributions. It's usually in an attached schedule. Clarify exactly when distributions will be paid. For example, at the end of every quarter, any amount of cash that the company holds over $100,000, the managing members will make an earnest effort to pay that out as distributions. Or clarify what type of distributions will be paid. Will the partners also receive distributions in the forms of tax payments or distributions in kind? Get it all spelled out, have these conversations with your clients on the front end. Sweat equity and workload disparity. If you work with partnership disputes enough, you will come to hate the term sweat equity. It is never accounted for in a contract properly, and it only comes up when the partners are already fighting. So a good example of this is, one partner says, I deserve more ownership because I sank $20,000 into the business to keep it afloat. And the other partner says, yeah, well, I was the one who was here 80 hours a week for however many years. My ownership should increase because of that, of the sweat equity I put in. Well, you can account for both of those things early on. And if you're getting into drafting operating agreements, I think it should be a default thing that you do. For example, a partner conducting work on behalf of the company may only receive regular employee compensation for such work. Or a partner who provides additional or money to the company to kind of help it continue to stay afloat, classify that as a loan that has to be paid back before distributions. But then you explicitly clarify that neither of those things actually increase their ownership. So that way, down the line, when they're fighting about, well, I put money in, well, I put effort in, well, they're going to be less likely to fight if it doesn't affect the ownership of the company, and both of them are entitled to be paid for that, paid back for that in a fair way. Adding new partners. So this could mean multiple things, but clearly spell out the steps that must be followed when a partner wants to sell their shares. I'll typically include a pretty detailed offer, counteroffer process that sets certain timelines and requirements. So if they're in a dispute, it holds whoever is wanting to sell or buy those shares accountable. But it also allows the partner some freedom to negotiate if they're not on bad terms. Someone just wants to leave and the partners want to work together. They don't want to be boxed in. Clarify what happens to a partner's shares if the partner dies. How is their ownership accounted for? Is the company going to purchase it back? And if it is, identify if those funds are going to go to a certain beneficiary, a spouse, a child, or into a trust, or maybe somewhere else. And some partnerships, I've had clients, they prefer to hold some sort of mutual life insurance policies that are really intended to kind of reimburse that partner for their shares when they pass away. And then those shares are then reabsorbed by the company. And so these types of things are why I put so much emphasis on those early detailed client discussions, because all of these things can be addressed on the outset and they don't have to become problems down the line that threaten the business. Next slide, please. So wading into a partnership dispute. So you in this scenario, you didn't form the company, but you're retained to come in. There's a partnership dispute going on. They want you to come in and represent somebody. Once again, first question, who are you representing? Is it a partner or is it the company? And you should not stray from past engagement. I know that this seems simple and straightforward, but I've run into this several times. I just ran into it again last month. I entered a partnership dispute on behalf of one partner. The other partner already had an attorney. It was a 50-50 split. They always are. That's also a bad idea. We'll cover that later. But they already had an attorney. And as we started talking, I realized that other attorney actually appeared to kind of have been working with them to form the company and was the attorney who drafted the operating agreement and was now only representing the interest of one partner. And he tried to kind of retroactively go back and say, well, no, in all of our discussions, we only represented the one partner. But he failed to secure that in an engagement letter. In fact, he failed to get an engagement letter at all, and his entire firm had to withdraw. And the validity of the operating agreement, has been called into question. So it just created a bunch of problems, ethical problems for them and their firm, and just practical problems for the business because the governing document, it's unclear how binding it is now. Next slide, please. So assuming that you're representing one of the owners, once again, capture the scope, the nature of that representation in very good detail. Had that attorney from my last example gotten a detailed engagement letter, it would have helped everyone understand, throughout the entire process, regardless of whether he was only representing one partner, but it would have helped everyone understand where his client duties actually belonged. Also explicitly clarify what work you'll be doing. If you're hired to negotiate a partner buyout, you don't want to get stuck representing them throughout a judicial dissolution because you just failed to clarify the task you were getting paid for, you were being hired for. And then I have this question here of controlling partner versus sideline partner. If you're representing one of the partners, I think of a controlling partner as the one who's still running the business day to day. Usually, a sideline partner is a disaffected partner. And if you have a disaffected partner or a sideline partner, they're going to have less access likely to company documents, company information. You're going to have to get that from the other partner. That usually becomes a source of conflict as well. Next slide, please. And so again, if you're representing just one partner, you got to be careful and kind of get a good idea of what the nature of the dispute is. Are they arguing about what they want to rebrand the company as, or is one partner had got caught stealing from the company? And is that one disaffected partner, what's their disposition? Are they still mad, or they want to bring the whole thing down? And then you're going to have to kind of look out for your client's interest in the company by helping your client realize they need to take steps to protect the company while we work out this partnership dispute. Some things to think about, and I have seen all of these be drug into partnership disputes. Does that disaffected partner have access to your bank accounts? Can they contact your customers? Can they call up your vendors and start canceling vendor contracts? Can they fire your employees? Can they hijack your social media and your marketing? If there's depending on the nature of it, if it's really volatile and the disaffected partner is out there, they could be looking for ways to harm the company or your client's interest. And so you gotta prepare for that. Address partner to partner communications. If it's an amicable dissolution, it's not necessary that they can't email each other or something like that. Very rarely have I found that it's helpful though. And so I have had to ask our clients, stop talking to each other. Let the attorneys talk to each other because, we would be making progress and then they would come back and they got into a 75 email thread argument about, the future of someone's favorite, computer monitor or something like that. It's just not helpful. And then cling to that operating agreement that you spent so much time crafting in the beginning, or someone did, because if you're coming into the dispute, probably shouldn't be the same person who did the operating agreement. Next slide, please. Okay, so now this is a little bit different. Assuming that you are coming in and you are representing the company and there's a dispute amongst the partners. It's kind of a rare thing, but it's happened to me and it's an interesting place to be because everybody's mad and you don't represent any of them. So you're going to want to identify the nature and dispute ahead of time. If it's a transfer of interest, are we trying to expel a partner? So you can kind of decide where your boundaries lie. And once again, clearly capture the nature and scope of your representation in a very detailed engagement letter. When you're representing the company and not any of the partners, it's much more likely that the written documents and the written communications are going to be your lifeline. if someone's going to accuse you of some ethical violation down the line. And so take time, I would say, to meet with all the partners ahead of time, discuss the case at length, really get their buy-in, and have them all sign your engagement letter if you can, if everybody's willing to do that. That kind of covers you down the line. Next slide, please. Like I said, it's important that you take consistent steps to avoid any appearance of bias or underhandedness. Everybody's angry. You should assume, it's safe to assume someone's going to complain about you taking sides or something down the line. That's why these common communications, the common documents, they really add a lot of value for protecting yourself. If you're talking about the company and you're trying to steer them into a mediation as a non-personal attorney, and they start to try to ask you advice constantly, my constant refrain, I put it in every letter, I put it in every communication. If you have questions about your own interest, you need to hire your own attorney. Inform them that your communications with them are not privileged. They're not your client. That's not a privileged communication. I'll regularly say it's not in my interest to tell anyone. I don't have any intention of telling anyone, but the attorney-client privilege is not there. That you might be expecting. And that comes to this, attorneys who have been around, I'm sure you've heard of Upjohn warnings. Upjohn warnings get their name from that related court case, and it refers essentially to an attorney warning to a company partner, executive, or another employee that, I represent the company and the company's interest, not yours. You need to make it clear. And if it's a really contentious partnership dispute, I've basically had a written version of it. I've read it off to them. I've had them sign it so that everybody knows who I represent and they can't say I wasn't looking out for their interest or I was looking after someone else's interest. Regularly communicate with all parties. If they're more amicable, keep them on the same email. If they can't stand each other, I issue letters to the shareholders or letters to the partners, and it's addressed to both of them. And I send it to both of them in separate emails at the same time. This all, it not only protects us from the ethical challenges or ethical, traps down the line, it helps the partners feel like you're being honest and that they're being dealt with honestly. And so everybody's happy if you take these steps. Maybe not happy, but happier than they would be if you keep them in the dark. Next slide, please. Yeah, okay, so I'm not going to go into all of these, but regardless of whether it's you're representing the company or a partner, these are things that I have found helpful in all of the disputes. So if a transfer of interest is involved in either way, a partner wants to be bought out, wants to sell their share to someone else, first step is get a CPA who knows what they're doing to do a proper valuation, not of the whole company, but of the share that's at issue here, because that will give you a starting point to talk about. I can go into these discounts here a little bit, but I don't want to get into the weeds because I know we have a micro enterprise business owner who we all want to hear from. So I'm happy to talk about these later or contact me directly at this information, and I'd be happy to discuss these problems with you.
All right. Thank you, Luke and Ebony. You guys gave some really wonderful information. Louisa, I want to make sure that we can speak with Shelby. Shelby, can you unmute? Here she is. Hi, everybody.
Hey, okay.
Hey.
Hi
So,
there.
so our feature clients, I would say star client is Shelby Farr. She is a wonderful entrepreneur who is growing by the minute. First she started out, selling cosmetic products and making her own perfumes, and then she decided to create a fragrance bar. And the name of her business is Shelby Marie Luxury Fragrance Bar, and I'm going to put a link to Channel 4 coverage of her business so you know where she is. But Shelby, hi, I just wanted to ask you a few questions real quick.
Sure.
I know you got to dart out at one, so
Take your time.
all right. So, what made you start your business?
So I started my business because I was making the products for myself, my luxury body products, but it gave me so much self-love and self-confidence that I wanted to share with other women because I
Mhm.
worked in retail and I realized a lot of us didn't love the skin we're in or the bodies we have. So I'm like, I want to share the love that my products, the confidence that my products make me feel. So that's how I started.
Very good. And when did you officially open your business?
Well, I've been an entrepreneur. I haven't had a job, a full-time job in 10 plus years. So I've been an entrepreneur for over 10 years. And in 2018 is when I started everything legally. And I've been going, and the fragrance bar, it's been open for 3 years.
All right. All right. And I know that you came to us around that time. So how did our micro enterprise program help you in your
You
business?
guys have helped me in so many ways and continuously helped me. So the main thing, well, right now we're working on getting me trademarked. My name,
Mm-hmm.
Shelby Marie. Getting that name trademarked in my industry is a must. And
Mm-hmm.
also I've had help with contracts,
Mm-hmm.
having my employees sign non-disclosure because we
Mm-hmm.
make our products and it's a lot of information that goes into making our products, so they have to sign that. And also lease agreements. Like one of my biggest headaches was a lease agreement, and that
Mm-hmm.
lease agreement, Marlene helped me get through it. I was ready to throw in the towel.
Yes. I remember that. And
Hmm.
and I just wanted to point out too, real quick, the the contracts issue was something that came up during COVID,
Yeah.
where she wasn't able to operate her business, and a contract that she had with a credit card machine company was kind of hounding her and saying, well, you need to keep paying us. And she just wanted out of the contract. So we had to
Yeah.
step in and help them and say, COVID is a thing. You can't just act like everything is fine. So we got that taken care of. So that's really cool. How has your business expanded? Have you I know personally the answer to this question, but go ahead. If you've
Well,
gotten
it
a new
has expanded
location.
to where I started in the marketplace. And then
Mm-hmm.
I went to Soulard Farmers Market. I've been there for 5 years. And being at Soulard exposed me to more customers, of course, and it exposed my brand. And I even applied at Soulard when the court system was closed. So it was hard to even get into Soulard and the hoops I had to jump through with the city to get in there. But I made it. And I've been open for 5 years there, and saving my money from Soulard helped me get my brick and mortar, which
Mm-hmm.
like I've been doing that for 3 years. And my customer base, oh my gosh, I would have to run numbers, but I have over 5,000 customers, really. And it's such a blessing. And just recently, my numbers have doubled. Within the last month, my numbers have doubled with the exposure of the fragrance bar itself.
Wow. Do you offer any kind of specials for holidays? Just out of curiosity, because
Of
Mother's Day
course.
is coming up and stuff like
Yeah, so of course we always have a special during the holidays, especially for the ones that love the perfumes. And it's not just women, I will say, because we cater to men too. So on Valentine's Day, we had different date night packages. Of course, for Mother's Day, we have Mother's Day packages and we're serving them dinner. Yeah, we have packages. We always have specials for the holidays.
very
Yeah.
good. Well, thank you, Shelby. I got to run and answer some questions that we've gotten during
Okay.
our presentation, but thank you so much
Thank you
for
for having me,
joining
and
us.
thank you for helping me in my business.
Yes, ma'am. Of
All right.
course. All right. Take care.
Bye. Okay.
Bye. All right. So let's jump on to the questions, everybody. I know there were a few, and I just wanted to talk really briefly. Are there materials? Yes, the materials will be sent to everyone. Um, a micro enterprise, are there size limitations as to revenue or profitability? Not necessarily. We look more at sort of, as far as having a client, we look at the household income. And like I said earlier, they can't go above 300% of the poverty level. So, um, and Luke, did you have anything you wanted to add to that, or no? Okay, sorry. I just saw you kind of pop up. Um, and then how did this program differ or share similar services to SLDC's Northside Economic Empowerment Center? Well, we work alongside them because they're helping entrepreneurs. They're like an entrepreneur incubator hub. And so they bring in different people to help the entrepreneurs, and we're one of those people that they try to bring in, or other programs like theirs. We definitely work with a number of other community partners like that, but we bring in the legal aspect of it. Let's see.
The next question, Marlene, I believe is directed to Ebony.
Yes, I was.
It
Yes.
is, and so it's from Parker. I'm not sure if that's a last name or not, but it says, thank you, Ebony. Why couldn't say a 50-50 interest member in a Missouri LLC include a shotgun resolution provision to resolve disputes in these cases of micro enterprise? I mean, they certainly can, right? To agree that they'll buy one another out or force that person to sell their interest. They most certainly can. They're not prevented from doing so. However, it is not always easy to get your friend or your spouse or your sister or your brother to say, hey, if this thing goes south, I'm buying you out. You're getting out of here. And they're like, yeah, that's fine. Like it's never that easy sometimes. And so, like I said, they most certainly can, right? It's not that they're prevented from doing so, but it's not always as cut and dry as it is for an attorney to say, this is what you need, let's move on, right? Luke, I know that was going to be on your next slide. I didn't know if you wanted to include something that I haven't mentioned from the ethics standpoint too.
Oh, well, no, I mean, shotgun clauses are certainly, it basically, it's a artistic name for what it actually is. And it forces people into, one party can make an offer, but they have to be also willing to be bought out at that same price. And it's kind of it's an extreme last resort. I have included it, after having everybody understand what it means and kind of the finality of it, I've included it. Usually though, if there's already a big dispute going on and they're looking at the implementation of a shotgun clause, you're probably going to have both sides walk away from it and kind of ignore it, and neither side want to implement it or enforce it because someone always gets burned, but it is possible to include it. I think it's much more beneficial, honestly. One of the things you can do is if there's a 50-50 partnership, is you can clearly define the roles of, this partner is going to handle the finances, the accounting, and, whatever other aspect is. This partner is going to handle the operations and the marketing. And so if the dispute is about one of those clearly defined roles and duties, then you can write in there that if there's a dispute and a deadlock as to marketing, then the marketing partner will carry the day. Or, really going towards mediation. A lot of my partnership disputes, if we can get them into mediation and kind of explain their positions to a judge, that goes a long way too. So the idea is not only to structure an agreement that functionally works on paper, but an agreement that will actually result in a resolution. And a lot of times shotgun clauses have the opposite effect.
Okay, so we are officially at the 1 o'clock. So I'm unfortunately gonna have to cut these wonderful guests off, but I just want to thank everybody for being here. Special thank you to our panelists for being here. I dropped a bunch of links and contact information. So if you're interested at all in getting involved with the micro enterprise program, feel free to reach out to any of us. Other ways you can get involved, join the Young Friends Board. And other ways to make a meaningful impact, make a donation. The link is in there. Follow Legal Services on social media. If you want to subscribe to the newsletter, we're a little over time, but click subscribe or contact one of us to figure out how. But I just want to thank everybody for their time today. And, it's important work that we're doing. Let's keep working together to build stronger communities and stronger businesses. So everyone have a wonderful afternoon. Thank you very much.
Thank you. Thank you everyone for joining us. Thanks, Katie. You did a great job.